Assalamu alaikum everyone. This is a video with a topic of essentials of acceptance. We've already learned earlier about the offer, the types of offer, what is proposal, what is the definition of promise, what is actually agreement, and how it could be enforceable by the law, and how enforceability converted agreement into contract, and what are the types of contract. Now, before valid contract, there is an acceptance by the offeree. Like if you offer someone, then that offer should be accepted by the offeree in order to conclude it as an agreement. And if that agreement can be enforceable by the law, then we can call it as a contract. So for the purpose of acceptance, there should be some essentials as well. Like as we already discussed, the essentials of an offer, of the essentials of a valid contract. So these are there are also the essentials of acceptance as well. So let's discuss about the acceptance essential. So the first essential is absolute and unconditional. An offer should be accepted without any condition. If any condition is imposed on an offer, then it turns out to be a counter offer instead of acceptance under the Section 7. Like if someone offers you that he want to purchase your car at rupees 7 lakh, then then your acceptance should be in the form of yes with all terms and conditions. Okay, but if you impose any condition that okay, I want to sell my car but not on the 7 lakh, there should be 7 lakh 1,000 rupees, you have increased the 1,000 rupees. This is not an acceptance. This is actually a counter offer, not an acceptance. So, due to that counter offer, you have discarded the first offer, and now this is a new offer, and this is a valid offer. Now the other person is an offer right now, so it is all about his discretion that he will maybe accept your offer or not, but this is not and can be called as an acceptance. So acceptance should be without any further terms and conditions as well. Okay, so this is the first essential of acceptance, that it should be absolute and unconditional according to the Section 7 of the Contract Act 1872. The second one is a communication. Under the communication, it has been written that the acceptance may be complete when it is communicated to the offer. An offer can be accepted by words spoken or written or through conduct of the person. As we discussed in the types of contract, there is an implied contract where the acceptance may be given by any act or by the conduct of the offeree. Okay, it may be a written or spoken as an express contract, as we discussed before. Further, a valid acceptance is communicated either by the offeree himself or any person authorized by him to communicate to the offerer. Now, there is a twist one again. What we have learned before under the specific contract, a specific offer, that the specific under the specific offer, the acceptance should be from the specific person to whom the specific offer has been made. But now here it has been mentioned that the acceptance can be given by that specific person or by any legal representative, or the person authorized by him can also give the acceptance on behalf of the offeree. So, under the postal rule, what is actually the criteria of acceptance? What are the rules and regulations? What are the protocols under the Contract Act 1872? The communication of acceptance by post is complete as against the proposer when it is put in a course of transmission. Okay. In case of acceptance made by post, the proposer becomes bound as soon as a letter of acceptance is posted, even if such letter is lost or delayed. Okay, now in the second line, the communication is complete as against the acceptor when it comes to the knowledge of the proposer. In case of acceptance by post, the acceptor become bound when the letter of acceptance is actually received. Before that, acceptor may revoke his acceptance. Now, what is this all about? You have to learn about it. Okay, when offeree receive the proposal from the offer, the and now the offeree feels that okay, he wants to give his acceptance under the postal rule. Okay, so he write his acceptance and just dispatch it to the proposer. Now the proposer has become bound as soon as the letter of acceptance reached to himself, even if that letter has been delayed or lost during the course of transmission. The proposal or the offer is still bound with the person to to whom he has made his offer, because acceptance has already been given by the acceptor. Okay, in the second line, the communication is completed against the acceptor when it comes to the knowledge of the proposer. When the proposer comes become aware that the acceptance has been given by the offeree. In case of acceptance by post, the acceptor become also bound when the letter of acceptance is actually received. Before that, the acceptor may revoke his acceptance. Okay, now in this case, uh, make it like make it more easy. Mr. A propose Mr. B, okay, that he want to give service consultancy services to Mr. B in order to make a financial report of his business, because Mr. B is really nowadays worried about his business activities, and his portfolio has been gradually going down or decline. So Mr. A has proposed Mr. B that he wants to give consultancy services. Okay, Mr. B is ready, and Mr. B is also given acceptance through a postal rule. That is, he dispatch his acceptance. Okay, he did dispatch his acceptance to Mr. A through TCS or Pakistan Postal Services or DHL or Lippert Company, any company. Now, after dispatch the acceptance, now Mr. B is feeling insecure. He felt that no, it is not a good deal. I want to revoke my acceptance. He write the revocation letter, and uh, and very quickly dispatch the same to the proposer. Now, what will happen? He has dispatched the acceptance as well and the revocation as well. If the acceptance letter has reached to the offer first, then the communication of the acceptance will be completed and the both parties are bound into the contract. But if in case revocation has reached to the offer first before the acceptance letter, then the revocation will take place and there will not be any contract between these two parties. So this is the postal rule. The communication of which letter will come first will have to be implemented. Okay, so first come first serve basis for the postal rule. Now, contracts over telephone, telex, and the fax. Okay, also these are the old medium of you can say communication, but under the Contract Act, it has been written the contract by telephone, telex, fax is treated on the same principle as an oral agreement made between two parties when they are face to face with each other. Now, in such cases, the contract will complete only when the acceptance is received by the proposer and not when it is transmitted by the acceptor. Okay. In this case, when you're making any agreement through fax, through telex, through telephone, then your acceptance will only be completed when it is received by the proposer, not it is in the course of transmission. unlikely the postal rule. Okay, so when it will be reached, it will be counted as an acceptance. If it will not reach, then it will not count as an acceptance. So, so this is the case of communication. Now, there's another one that is reasonable time. A valid acceptance is when it is accepted within a time is specified or within a reasonable time where no time is specified. Like Mr. A proposed Mr. B, and he said that you have to give me your affirmation within a week. Now, this is the prescribed time he has given to the Mr. B. Now, Mr. B is liable to give his acceptance within a prescribed time, not more than that. Okay, if he's not given his confirmation in the prescribed time, then it will be presumed as a negative answer. But if there is no prescribed time, then there should be a reasonable time. So under what is the definition of reasonable time? Is simply uh, the reasonable time can be judged by the nature of the business transaction, by the relationship between these two parties. Like if two parties are frequently working with each other and they have several contracts which they have done before, then they knew it that what the other party is looking for. If I will accept the offer of that party, then in how many days I will have to deliver these goods to that party. So this is a reasonable time, and it should be understood by the nature of the business, the nature of the transaction, the frequency of the transaction between the two parties. There's a reasonable mode. Accept, Acceptance should be made in the manner specified or in an unusual manner where no mode is specified. If the proposal prescribe a manner in which offer is to be accepted and the acceptance is not made in that manner. Okay, so if offer give you an offer and is prescribe a more that I will get acceptance from your side if you will deliver your goods at my warehouse. Now this is a prescribed mode which you have to follow. So if you follow his instructions, then it will be a specified mode. But he is not specified that where he want the delivery. Then it is a reasonable mode that he knew it. There is a production unit of that person where you have to send these goods. Okay. Otherwise, you are not. It is something very unusual that you are delivering these goods at his residency. So there's a reasonable mode, and what is the definition of reasonable mode? It is against the definition like a reasonable time. It determined according to the nature of the business, the frequency of the transactions, the history of the transaction which they have concluded before. Now, the offer shall, in this case, when acceptance communicated to him, insist that the proposal shall be accepted in the prescribed manner, not otherwise. If the offer failed to insist with a reasonable time, it is deemed that he has accepted the performance. Okay, now, an awareness of proposal. The acceptor must be aware of the proposal at the time of acceptance of the proposal. Of course, he should be aware of it. He should not give his assent or affirmation without knowing the terms and conditions of the offer. Okay, so he should knew about what is actually the proposal, what are the terms and conditions, what are the obligations if he will give us an affirmation in the future. So this is also one of the essential of an acceptance. Now, before lapse of an offer, the acceptance must be given before the offer lapses or is withdrawn. Okay, so if someone give you an offer and said that you have to giving your acceptance within the 2 days, though after 2 days the offer will be lapsed, or like if he will not give you is a specified deadline of 2 days, but you were in, but the acceptance is still pending, then the offer may withdraw his offer from his side from his side. Therefore, you are no more obliged to give the acceptance because there is no more valid offer at the end of the other person. Now, negative confirmation. A proposal is not accepted, the offer remains silent. It cannot be in the form of negative confirmation. That is, if it is not accepted within specified time, then it will be presumed to have been accepted. it. Okay, business according to the contract act, it is discourage, it discourage the negative confirmation or the silent of the offeree. Okay, if that person is silent, then it is not a, it means the proposal has not been accepted. Okay, like if any party is not giving the consent or decline the proposal and is still acting like a neutral, then the contract act stated that no, if offer remains silent, the proposal is not accepted. The acceptance is not valid. It lacks the essentials of acceptance because it should be communicated to the offer. Okay, so these are all the essentials of an acceptance, and they all should be available within acceptance. Otherwise, acceptance can be called as invalid, and there will be no proper or legal agreement or a contract under the Contract Act 1872. Thank you so much.